Call this meeting of the Commission of the Town of Gulf Stream to order. Please rise and pledge the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Rita, would you please call the roll?
Commissioner Gainer.
Here.
Commissioner Stanley.
Here.
Commissioner White. Here. Commissioner Orthwein. Here. Mayor Scott.
Here. Had an opportunity to review the minutes from the last meeting of December 12th. Are there any additions, corrections, comments? If not,
Move approval of the minutes.
second. Rita?
Commissioner Gainer.
Yes.
Commissioner Stanley.
Yes.
Commissioner White. Yes. Commissioner Orthwein. Yes. Mayor Morgan.
Yes. Additions to the agenda items, there is one. Mr. Randolph needs to address an item for the Commission's consideration regarding a lawsuit against the Sweet Apple Law Firm. Rita, where would you like to put that on the agenda? We do it just after the ordinance?
That's fine, Ed. Unless you want it sooner.
No, I think that goes right after where you have items,
All right,
items
then.
about mayor and commission.
Item 9C.
How about 9B and B, C? That's all right with you. There may be some comment from.
Yeah, let's make it B,
All right.
and we'll do items with mayor and commissioner as C.
All right. This will be an item by the attorney.
Correct. Okay, anything else? Our next meeting is February 13. Anyone know at this time whether they cannot attend? Good. Public comments. Any comments from the public? Yes, sir.
Good morning.
Would you please come to the
Sure,
podium?
absolutely. Good morning. For those of you who don't know me, my name is Julio Martinez. I live over in Place Soleil, and I used to be the former president of the Homeowners Association. And I've had the privilege of working with most of you at hopefully making the town much better. And what I really came out here today to reach out to you guys. Now I'm retired, so I have a little bit of extra time, and I want to come back and give to the town. It's an honor living here. All I can say is, Rita, you're not perfect. Bill Thrasher, you're not perfect, but I wouldn't trade you guys for anybody else. As far as town commission is concerned here, you guys do a phenomenal job when I walk around this neighborhood or that neighborhood, any neighborhood here in Gulfstream. It's phenomenal what we've got going on. Chief of police, same thing. Crime rate, extremely low. So when I look at other towns, and I try and see what's the perfect model to follow, it's this one right here. So with that said, I'm just talking from the bottom of my heart. I don't have any notes or anything like that right now. The only thing I can say about the commission is you guys, you're gonna have to take a pay cut next year. You're getting paid too much money for what you're doing. No, actually, you guys on a bad day are better than most other town commissions. Best person on the best day. And I've had a chance to speak to most of you, and you guys really give a lot. And I just don't want that to go unnoticed. The other thing I just wanted to share real quick is, when the Pledge of Allegiance comes up, there's a lot of people that have fought for this country who can't get up, who would pay anything in the world to stand up when that Pledge of Allegiance comes up. They're disabled, they died, they fought for this country. And as far as I'm concerned, here in the town of Gulfstream, I'm living the American dream. And it doesn't matter where I am in the world. If I hear the Pledge of Allegiance, I'm going to stand up in respect to all the soldiers and all the folks that have given us the freedoms that we're going to be able to express today. So with that said, that's enough for me, but really you guys deserve a lot of credit for all that you do, and I just didn't want that to go unnoticed. And you can count on me being here at all these meetings.
Thank you. And we do appreciate
observed, you're too young to retire.
Mr. O'Hare.
Happy New Year, commissioners and staff. 2015 is going to be significant. About a year ago, I told you about the handicap access violations in Town Hall. I told you about the poorly designed ramp from the parking lot, and voila, a new ramp was built. I told you about the restrooms. Voila, they've been remodeled. I told you about the poorly designed security system pad, and now I notice a new pad's been installed lower. Very good. I told you about the locked fire doors, fire exits have to be open during Town Hall, now they are. I told you about social security numbers on the town's website, now they're gone. While we're on the subject, the locks on the restroom doors are too high. A handicapped person can't use them. The ramp needs a railing. I'm telling you this so a lawyer doesn't come in here and sue you, just for your information. I don't know why. Maybe it's because I was raised in Catholic school, or all the years as a Boy Scout, or the training I got from my father, who was a 10th Mountain Division against the Nazis. But when I see a problem, I want to fix it. And when I see something wrong, I want to right it. About 6 months ago, Mr. Sweetapple, on behalf of Mayor Morgan, told me to dismiss all my complaints against the town. In exchange, the town would exclude me from the 40-page RICO action that was prepared at that time against Mr. O'Boyle and myself. It was a take it or leave it offer. A few months ago, Mayor Morgan made the very same take it or leave it offer to me again. I don't hear very well, so sometimes I have to go back and read the minutes to know what happened at the last meeting. Now I learned after examining those minutes, the commission has given no authority to Mr. Morgan to act on their behalf in these legal matters, except for some bar complaint, which I don't know anything about. Mayor Morgan's acted without commission knowledge, direction, or approval. Does the commission want that to continue, or are you going to give him authority now to act on your behalf with the attorneys? No answer. The threat of an impending RICO claim against me is terribly debilitating. It's disturbing to me and my family, not knowing if people are now casting me in the role of the town's ugly description. It is stressful and destabilizing not knowing if I will be charged with organized crime and have to defend myself. I'm asking you all again, will you here and now retract your previous claims that I conspired to defraud the town?
This is a public comment section, not Q&A.
Thank you very much.
Anyone else? Mr. O'Boyle,
Good morning.
welcome.
Good morning, ladies and gentlemen. My name is Martin O'Boyle, 23 Hidden Harbor Drive, Gulfstream. I had a few words to say, but before I say them, I want to respond to Mr. Martinez. The United States Supreme Court allows me to sit down, sir. The United States Supreme Court is one of 3 bodies of government. If you don't like what the United States Supreme Court does, you should petition them to change it. Having said that, I come here today in peace. I come here with the hope that the town commission wishes to end the litigation and expense between us. I see it spiraling out of control, something that I really don't want to see happen, and I assume that the commission does not want to see happen. The bills are going to be in an area that none of us probably have ever imagined. So it's in this spirit that I request that the commissioner or their counsel, as the case may be, agree to a sit-down with our council, with us. There is no lose and all win. If nothing could be resolved, we've lost nothing. If something can be resolved, we save me, you, them a great deal of money. And there are other thorny items that could certainly be put into a settlement agreement, as the plethora of lawyers up there know. Despite what I just said, I ask that you please don't make a mistake. That my desire for peace is laced with fear. So I'm clear, I want you to know that I fear not our mayor, and I fear not our commission, and I fear not our solicitor, and I fear not your elusive RICO action. But nonetheless, I think it's in everyone's best interest to try to come to a resolution recognizing no loss, all gain. Unfortunately, I've been out of town for the last few months, and I haven't been at a meeting, but I have watched them, and they're great on TV. We have a decorum policy here. It's not being enforced. I would ask that either the solicitor or the chief of police please revisit the decorum policy and enforce it as it should be. Last night I read the agenda and I saw a sign, a new sign ordinance. Where did that come from? Or are we going to talk about it later?
This is a comment period, not a
Right.
question and answer. Will be brought up later in the agenda, and you may ask questions at that time.
I appreciate it. Thank you all for allowing me to
Thank
speak.
you, sir. Let's move on to reports. The underground report, Mr. Brown.
James Brand, Browning and Gillespie, to be here this morning. As I had indicated in the last commission meeting, we were expecting to get the prints from the contractor, and we did get them the next day, and they've been forwarded on. The binding cost estimate from Florida Power and Light Company was delivered this morning at 8:30. We were able to execute that. Haven't looked at it yet, but we have it in our hands, and we now can move forward with that. Right now in phase one, it appears that we're about 1/4% over budget if our expected expenses to complete the project are on track, and they're pretty close. We may not use quite all the landscaping money, but we're very close on the budget on phase one.
Excuse me, Danny, does that include the contingency in phase one or just the budget?
It's the contingency and the total budget including the contingency.
So we've used the contingency?
Yes. And that's indicated on page 5 of your package. The demonstration street light, I understand from the vendor, is being shipped. We're expecting a local distributor to be contacting us. They'll be delivering that to Town Hall, and we'll get that installed soon. I expect to get it in the next week or two. And those are the main points of the status at this point. We will be moving forward with the design work to try to get our packages put together before we can go out to bid for phase 2 as soon as possible.
Is the contingency in the initial budget for phase two proportionate to the contingency in phase one? In other
Yeah,
words,
yeah.
so-
The phases aren't, one was like rounded off 2.4 million and the other's about 3 million. Phase two is 3 million, phase one was 2.4 million.
So
The
phase
contingencies are
one,
proportionate.
around $300,000 in contingency.
Yeah, they were proportionate.
Would you say, based upon experience in using the contingency in phase one, that there really isn't a contingency in phase two, or are they totally separate issues?
I think phase two is gonna be tight. I think that it's going to consume the contingency in phase two also. Some of it has to do with the delays in getting AT&T and Comcast executed. And we're looking at other projects that we've seen in the past that we ended up dragging out.
But we've already paid for AT&T last December for the upcoming year, so
Yeah,
there's no way they can wiggle out of that, can they?
AT&T's contract says that they estimate their cost to convert and that the billing will be actual and will be trued up at the end of the construction. So we have paid their estimated cost. Comcast, typically their estimated costs are their cost. AT&T's varies. And they generally will end up being a little bit more than they estimated.
Do we have an active program to figure out how we can keep ourselves from overspending this budget? Because we've already paid for it. I mean, I paid for it, Morgan paid for it, we've paid for it.
Yeah, I think we had about 50% of the total project cost paid up front when the residents were given the option of paying it out front or financing it.
Well, needless to say, none of us want to go back to the residents of this community and say, oops.
Right.
So I guess I would say that you probably have to bring to us a plan that fundamentally says, is there any opportunity to shave from the estimated cost so that we do not overspend? Honest to God, if we overspend on this thing, given the effort we've put into it, and the assurances that we would not overspend it, if that does happen, quite frankly, it's hell to pay, I guess is the best way to say it. That's really something that we just don't want to have happen.
Right. And we work very diligently to keep the costs down.
I appreciate that, but, you know, and a contingency is just what it is. A contingency is there because you don't know everything, and you want to make sure that you've got something in there for what you don't know.
Right.
But we now have a year's experience actually doing the job. And so I would think we'd be better served now to go back and say, is there any way we can do this thing more efficiently in phase two so that we don't overspend? I hate to be a broken needle on this, and I apologize to the rest of the commission, but obviously I've put a lot of my time in this over the many years, and I hate to see it go off the tracks at the last minute.
Then
Raising good points. Take it as perhaps gentle encouragement.
I will. Thank you.
Any other questions? Any others, Bob?
No, thanks.
Thank you, Mr. Brent. Town manager, ethics training.
It's just a reminder that as of January 1, 2015, all elected officials have to go through additional training, 4 hours of training. There's 2 hours on ethics, 1 hour on open meetings, and 1 hour on open records. We are working or expecting that the Florida League of Cities will provide the opportunity for you to do that online rather than set up a special meeting here or somewhere else. But as soon as that is finalized, I will make sure that you have that information, most likely that very same day.
When must that be completed by?
The information that I have so far is March 31st. So it gives you about 90 days from January 1. However, there aren't any online training options right now. The Palm Beach County League of Cities has put together a Palm Beach State College opportunity. I think it's the middle of the month, but you have to go there for that.
And it's a demand on time. It's not a short meeting, so if one chooses to do that, they would have to allow, as I recall, it's in hours.
It's 4 hours, total 4 hours of training
So,
that you have to go through and complete, so I just really assumed that you would want the option of online training. I have been informed repeatedly that the Florida League of Cities is developing an online training program.
Well, please keep us,
As soon as I have that information, I've looked and asked other members to look for me this morning. And, there is nothing out there as far as information, and it will be, as soon as I get it, you will have it.
thank you. Architectural Review Board meets January 22nd. We'll look forward to the minutes from that meeting. Finance Director report, any questions?
I provided you, yes, provided you a statement, report.
Any questions from the commission on that report? Approved as submitted. Police Chief's report.
as submitted, please.
Any questions of the chief? Next, ordinance for our consideration. This is ordinance number 15/1.
This is for a first reading. An ordinance of the Town Commission, Town of Gulf Stream, Palm Beach County, Florida, amending Chapter 66 zoning of the Town Code of Ordinances at Article 7, North Ocean Boulevard Overlay District by deleting Section 66-327 signs in its entirety. Further amending Article 8, Supplemental District Regulation Division 7 signs. I'm sorry, did I repeat that?
No, you're on.
By deleting Sections 66-446, 66-447, and 66-448, and replacing said sections with regulations which establish new time, place, and manner criteria governing signs in the town, and renumbering pardon me, existing Section 66-449 undergrounding of utilities as Section 66-450, providing for severability, providing for repeal of ordinances in conflict, providing for codification, providing an effective date, this 9th day of January 2015.
Now this is an ordinance we've all had an opportunity to review. Perhaps the town attorney could explain the significance of it.
If I could, and first of all, I've made a couple of grammatical changes in the ordinance that you have before you that I'd like to go through. First of all, at 66-446A, I've added the word of, so it reads, the purpose and intent of the regulations in this division is to establish content-neutral graphic controls through the promotion of identification. I don't think the word of is in the document you have in front of you. I've also changed item 6 to read as follows. Allow the proper placement of legible and effective signs while avoiding the over-concentration and excessive height, bulk, density, and area of signs placed in the town. I believe those are the only, well no, there's a comma out of place, but I don't think that's substantive enough to bring to your attention because I can't find it right now.
Page 5.
Page 5, you may have already, item F on page 5, it says no signs other than government signs, comma, are permitted on public property or within the rights of way. And I don't think that you have the word town inserted in the rights, in the document you have. It just says rights of way. As you know, there has been a challenge as to the constitutionality, the facial constitutionality of your current sign ordinance, which is contained within 66-446 through 66-448. That ordinance draws distinctions between political signs, real estate signs, and other kinds of signs. Although we feel that the sign ordinance that you have and have had for some time is appropriate because of the fact that there is a challenge to the constitutionality of the ordinance. I have prepared this ordinance for you in an attempt to make your ordinance content neutral. Some say that if you have to look at the content of a sign to determine whether it's legal or not, that it's not content neutral and therefore not constitutional. So this ordinance has been drafted in a way so as to not distinguish between the type of sign or the language on a sign. It simply provides regulations relating to signs generally. And it has a definition of sign, and it has time, place, and manner regulations pertaining to signs, and that's what you can regulate, is time, place, and manner, not content. So it has provision which says no sign shall exceed 4 feet in height, including the supporting pole. The sign face of any sign shall not exceed 4 square feet. Each property in the town shall be permitted to have a maximum of 12 square feet of sign face. All signs shall be set back 10 feet from any property line. No sign shall be erected or placed such that it blocks the views of any government sign or the sight lines of traffic, street signs, or traffic signals. No signs other than government signs are permitted on public property or within the rights of way. No signs may be attached, affixed, or painted or otherwise placed upon any dwelling or other building associated with a dwelling, including but not limited to sheds, carports, garages, and pool houses. And it states government signs are not subject to the restrictions in subsections A through G above. We do have an exemption for mailboxes, which are regulated by the federal government to be allowed within the rights of way. So that's the purpose of this ordinance. We have also deleted from your code that section relating to signs at section 66-327, which states signs shall be prohibited within the North Ocean Boulevard Overlay District except the following. And then it distinguishes between the types of signs that can be allowed in that district. I thought it best to delete that section in its entirety and just have a straight regulation in regard to time, place, and manner of signs in general, so as to not allow for exemptions for real estate signs, political signs, or even make any distinguishing remarks between those. I'm happy to answer any questions that you may have in regard to this. Rita has given it to you in advance, so you would have an opportunity to look at it and ask me any questions that you might have. I think it's important that you look at 66-446, which sets forth the legislative purpose and intent. And I think, for the record, I'll just go through those. To preserve, protect, and promote the public health, safety, welfare, and in general. Preserve and enhance the aesthetics and physical appearance of the town. Protect and preserve the image, character, style, and quality of life that the town desires. To minimize visual distractions. To safeguard the public use and nature of the town streets, etc., etc. And I don't think you have it, so all of that doesn't need to be read. But the whereas clauses recite some of the case law relating to signs and the constitutionality of signs, and provides that although we are a municipality may regulate aesthetics, that we need to make sure that our ordinances are content neutral and are simply time, place, and manner restrictions. So that's the purpose of this. I would recommend it for first reading today and second reading at a subsequent time.
Any questions of council?
A very general question, which is, when this ordinance is eventually approved and becomes law, will people notice the difference? I mean, just a general question. It seems to me that
I'm not sure that they would notice.
I appreciate, understand, and applaud you for taking the time to really think this through. But I read it 2 or 3 times, and I have to say, it's just common sense almost. It follows the law, and it's...
Yeah, I mean, I don't know that you'll notice the difference. You know now, this will allow 4 square feet, a sign to be 4 square feet. You now have a distinction between real estate signs and other signs, and your real estate signs are required to be only 2 square feet. In answer to your question, I don't know how much people will notice the difference between a 2 square foot real estate sign and a 4 square foot real estate sign, but it is a change, and it's one you need to give consideration to prior to the adoption of this ordinance. And you need to be aware that there will be some changes.
I would think there'd be some changes. I agree with Bob. I don't think it's terribly significant. I think facially our current ordinance is constitutional. However, the courts do appear to be split on interpreting a number of these provisions, and so this ordinance goes a long way to essentially tracking the middle and allowing, I think, for a more neutral interpretation of the ordinance, which protects us from lawsuits such as the one that's been filed against us on our current ordinance. So if this goes toward helping protect the town, then I think we should do it.
I agree.
Any other questions? Questions from the public?
Thank you, Mr. Mayor, for the opportunity to talk on this law before it's passed. I understand Judge Middlebrooks told the town that existing ordinances are constitutionally faulty. Mr. Randolph evidently disagrees with Judge Middlebrooks. The proposed replacement ordinance is confusing to me, and so I know how to properly comply and avoid a code enforcement action. I asked the commission for some clarification. First, is it correct that a non-conforming sign will be able to remain? Okay.
There are, I don't believe that temporary signs would be something that would be able to remain, but non-conforming signs that are part of a structure, such as a sign that's affixed to a condominium and has been there prior to the adoption of this ordinance, would be grandfathered in. But I don't believe that anything that is of a temporary nature would be grandfathered.
Thank you, sir. I agree with the town's purpose in keeping Gulf Stream beautiful. I don't want to see a whole bunch of signs either. I was concerned about the Gulf Stream Club, the Gulf Stream School. There's a lot of existing signs that don't conform, and if they once conformed and are so therefore not conforming, they should be exempt from these kind of regulations. You did a great job summing up the ordinance. The proposed ordinance defines sign as any object manufactured in any manner whatsoever used for attracting the attention of the public to any subject. That's broad, and I can understand why you need to be broad. The sign can't be any bit more than 4 feet above the ground, can't be any bigger than 4 square feet, which is 2 by 2, and can't be more than a cumulative 12 square feet, which is 3 2 by 2 signs, or less if you count both sides. It's got to be 10 feet back from the property line, can't be attached to the house, can't be on public property or in the right of way. I think that's the same. I took some pictures around town. I wonder if I could give them to the clerk if you're interested in following along with me, or I could just show them to the camera.
Sure.
There's 5 sets there. The first picture is my neighbor's lemonade stand. It's a temporary sign.
Just hold a sec till we get your.
Oh, I'm sorry. I just wanted to make it as brief as possible. I have 2 cute neighbors, like to sell things on the side of the road, and I'm wondering if there would be an exemption possible for a short duration, like 1 day. If a sign goes up selling lemonade, are they gonna be facing code enforcement? I know that seems ridiculous, but this ordinance is very specific. Page 2 and 3. Christmas is just here. Holiday lights, inflatable Santas, those are all objects calling attention to a specific subject. Will they be exempt? 4 and 8. There's a lot of informational signs around town. Gulfstream Club has in and out. There's service entrance signs on some of our bigger estates because we don't want, some people using the front door. Beware of dog, no trespassing, private property, these are in exhibits 4 and 8. Security, little signs like on Commissioner White's house, little security signs saying ADT is protecting me. Comcast has signs, and AT&T has little label signs in the right of way. Will those be exempt? Exhibit 5 and 6. People in town love Halloween. I mean, you'll recognize those houses, little foam gravestones and the ghosts hanging from trees. Those are all objects meant to call attention to a subject. Will they be exempt or at least limited to a certain period of time? Perhaps before and after a particular holiday. 7, 9, 10, and 11. Signs that do not conform to the town's existing sign ordinance, that were never permitted, and therefore can't claim non-conforming status. Will they be subject to prosecution now? And I give you a picture of the 75-year anniversary sign at the Gulfstream School, which is on the property line. It's too tall, too big. It's got a whole bunch of stuff going on, but it was never permitted. I did public record requests. There's no permits for those signs. But the code says every sign, except a real estate sign, must be permitted, the old code. Finally, signs on vehicles, Exhibit 12. Trucks come in and out all the time. They say plumber, air conditioning, you name it. They're on public property. It's an object meant to call attention to a subject, a commercial subject. Are they exempt? Or if a plumber comes to town hall and parks over there, is he gonna be written up? Finally, A1A is a state road, not a town right of way. Will you be enforcing this code on A1A's right of way, since it's outside your jurisdiction, but well within town limits? All right, so this is just comment, no comment back?
No, this is, I would defer to council on that, but I think the rights of way that are governed by the state preempt our jurisdiction. That's my understanding of it. I could be wrong. But I'm curious, you've done quite a bit of work here, Mr. O'Hare, and raised some very interesting questions. Is it your intention to file suit against the town? Should we pass this ordinance based on these signs?
I'm sorry, I'm having trouble hearing you.
Would it be your intention to file suit against the town if we pass this ordinance based on any of these signs that you've given us?
Well, it's my understanding that a citizen does not have standing to force a town to enforce or not enforce a law. I have no intention of that. I'm trying to protect the town and do the right thing. You're passing an ordinance that's broad, and perhaps it needs to be better defined. We have a lot of ordinances that are broad, and it's left to the discretion of Mr. Thrasher when he wants to bring someone to task on it. And as a property owner, I'd like to comply with the law. It's tough when you don't quite know what the law is. So I'm just asking what the law really is in regard to all these things.
Well, thank you for giving us food for thought.
Okay. Thank you.
Yeah, I mean, I don't know, Mr. O'Hare, that we have all the answers today, and I think you do raise some good points. And I think, I mean, for instance, a child's lemonade stand. The problem when you try to make an ordinance content neutral is when you start making exceptions, even for a child's lemonade stand, that could create problems. So those are issues that you may want to give consideration to and before second reading, but you raise issues that are very legitimate, but the more exceptions you allow, the more opportunity your ordinance becomes subject to attack.
Well, I understand you have a tough job, and this is particularly as tough when you've got federal constitutional issues involved in trying to keep a town beautiful. But for people on this side of the podium who have to follow the law, clear direction is so much better than leaving it up to discretion of whether one person's lemonade sign is okay for a day, but someone else's sign of Mr. Thrasher dressed as Napoleon is not okay. So I was just trying to be clear. But thank you for your comment.
And I think we can try to be as definitive as we can within the definition of sign. And it's not a definition that we just made up. It's a definition, obviously, that we've seen in ordinances that have withstood constitutional attack.
And you have to apply common sense to this. It's palpably absurd to say that a lemonade stand put up by a child for a couple hours to sell some lemonade on the street is going to somehow fall afoul of an ordinance and deserve some sort of prosecution. We're all adults, we're all family members, we're all part of a community. And I think the application of our codes has always been with the best interests of our residents at heart, and to try to apply things fairly and reasonably. And I would expect that this ordinance would be applied in the exact same way. Yes.
Mr. O'Hare, I want to thank you for obviously the energy you're putting into trying to make the town a better place. You know, certainly it's well meant, but on the other hand, I think, you know, when I walk around the town, I always, you know, at least spend 1 or 2 days walking around the town. I think when you look at the intent, and that lemonade stand, those young girls that stand there with their mother or their parents, I think the intent for them is very wholesome. I don't think anybody's ever complained. I think it comes from a kind place in the heart. So I think, you know, sometimes as human beings we have to look at things logically, what the intent of the sign is. Is it to defame somebody? Or is it to, you know, those signs are just goodwill? It's just a Norman Rockwell picture as far as I'm concerned when I'm walking around and I see those little girls with that lemonade stand. They certainly don't bother me, and anybody I've walked around and talked to in the neighborhood has never brought it to my attention. Not that I'm, you know, the voice of Gulfstream or anything else, but I try and, you know, kind of think about things logically. As far as like the Santa Clauses and the Halloween and all that, those are holidays, you know, that are celebrated across America, and people obviously put those, again, it's goodwill. You know, some people go overboard and do nicer Halloween decorations, and those are different signs. So I think at the end of the day, one of the things we actually have to do is look at things from a human nature, and what's the intent of the sign? Are we trying to defame somebody? You know, if we you know, associate Bill Thrasher or anybody in the town with somebody that's much more deviant, I don't know if that's wholesome. If I would want my kids walking around or my grandkids walking around and seeing that sign. You know, I would never mind my kids seeing somebody with a, you know, a lemonade stand or a Christmas sign. Again, I think if we can look at it, you know, as far as the intent. And I know you're doing a lot of work, and, you know, I would be more than glad to help out on whatever I can, you know, to kind of align our vision together so we can all work together and make this a better town. Because the one thing I would agree is there's a lot of talent here. And I don't want to fight against it. I want to be with it. And honestly, like I said when I first came over here, you guys are doing a phenomenal job. And I just wanted to, again, just share this stuff up.
Thank you,
Mr. Mayor, may I address that, because I think it's imperative that I put on the record. I understand this gentleman's good intent in saying what he is saying, but the point that I'm trying to make to you is that you can't regulate the intent.
The content must be neutral.
That's right.
Exactly.
So that's what we're trying to do with this ordinance, is make it content neutral, so we're not dealing with a sign that's allegedly defaming someone, or a sign that's posting a property for sale. That's what we're trying to avoid.
Exactly.
I think that one of the things, the transient nature of some signs, a plumber that pulls into a driveway with a truck that says Joe's Plumber, is not a sign as I think of it. It's part of his commercial property that he is doing a job and identifying who he is, and off he goes. I think to some extent, we may want to massage this a little bit to make it clearer as to moving or transient signs.
I don't think you need that, because this ordinance deals with signs on properties in the town.
Okay. Okay, but the photograph he shows here, I mean, that, again, you get down to common sense. A truck that's parked in your driveway with a sign on it is a transient, it's not a permanent sign. It's not even a sign that's likely to be there overnight. It's just there for a short period of time. Is that, to me, your proposed language is entirely clear that that would not be considered a sign as defined.
That's my intent.
Yeah,
It
I
deals with
realize
signs
that. I
on
don't-
properties. You
yeah.
can't regulate every
Of course.
vehicle that comes through the town.
That goes through the town, right? I don't
I
know.
think your reading of it is correct. That's how I read it as well. This is much ado about nothing.
Opportunity for more
Yeah.
public comment?
Absolutely, I'm sorry.
That's all right. Good morning.
Good morning.
It's a shame that we have to get to this point to look beyond what is natural and common nature and intent and good-hearted and as part of a community. But the idea to protect the image and the character and the quality of life is wonderful, and I understand that it has to be content neutral. I would just like to say, as a parent, and many parents over at Gulfstream School, to drive by and try to explain to your 4 or 5-year-old what a douchebag is because a sign's in front of a town hall is horrible. So I understand it has to be content neutral, but don't anybody be fooled that the decorum needs to extend long and well beyond this court, beyond this commission chamber. It's gotten to the point where it's ridiculous. And I'm sad that we have to be at this point.
Thank you. It is sad. There's unfortunately only so much that we can do.
May I?
You may, let me finish my thought though. But whether it's upbringing, whether it's attitude, whether it's narcissism, whatever it is, people want to act in that fashion, and if it's something that is constitutionally protected, there's little that can be done about it. You appeal to the good nature, as Mr. Martinez did, as you did, to people to act appropriately, with decency for the community in which we live. And that's the nature to which you appeal. Hopefully that behavior will change in the future. I'm sorry, Mr. Ward.
Good morning again. The First Amendment of the Constitution protects freedom of speech. It does not protect this freedom of speech of someone saying, hello, how are you? It protects the other side that is unpopular speech. Now, granted, there's popular speech and unpopular speech. The unpopular speech is protected by the Constitution of the United States, and I would assume that the residents of Gulfstream, the people in the county of Palm Beach, the state of Florida, and the United States of America would respect the laws of our land. And that's all I have to say about that. Mr. Randolph, I was writing quickly, and I don't know that what I wrote is correct. So if I can ask you, did you say the existing ordinance is constitutional?
No, I indicated that you have that the town has an ordinance in place at 66-327 and 446 through 448. It's been in existence for a long time that the town has not, until recently, had problems with. However, because that ordinance is being challenged, I believe that it is ripe and right for the council to look at it and consider the content neutrality and the time, place, and manner restrictions in the way that's been addressed within this ordinance.
I understand, but am I correct in saying that, or am I correct that I heard you say that the existing ordinance is constitutional?
I don't know that I said it just like that.
I
No.
did.
Okay, can you tell me
I
how you
believe
did?
it is, Mr. O'Boyle.
Pardon?
I think our ordinance is constitutional, but as you know, because you filed the lawsuits involving it, there's case law across the books. Judges interpret things in myriad fashions. There is uncertainty there, particularly when you get into First Amendment law, as you know. And so all we're trying to do is to clarify that, to make it totally content neutral so that we avoid lawsuits such as the ones you would bring against the town. So, is something constitutional? Is something not constitutional? That's up to courts to decide.
And they have.
We're trying to prevent lawsuits. We're trying to get the town to continue to function as it always has functioned, without the distractions and the expenses of lawsuits brought by people like yourself.
And I'm agreeable, I'm in full agreement with you with regard to that general statement that you made. So, just so I'm clear, you believe, notwithstanding the order of the court, that the present ordinance is constitutional?
I do.
Okay.
That's my opinion.
That's fine. And absent the content neutral provision, you would agree it's constitutional as well, Mr. Randolph?
Well, but Mr. O'Boyle, we do allow questions and answers here, and I'm happy to give you my opinion. I think for counsel to give a legal opinion based on an ordinance that is part of litigation right now would be inappropriate. I don't think he should respond to that sort of question. I've given you my own personal opinion for whatever that's worth. I'm not involved in that suit. For what it's worth, that's what I think.
Fair
And I
enough.
think that's probably the extent of it. If you want to comment on the ordinance that we're considering right now, that would be appropriate. But I
Fair.
think to further go into what you've already filed a lawsuit on, and which is subject to court review, would be inappropriate at this time.
Fair enough. The new ordinance, Mr. Randolph, do you believe it's constitutional?
Yes.
Okay, and you as well, Mr. Morgan?
Yes, I do, sure.
Okay, that's fine. Mr. O'Hare, I didn't see what he showed you, although I did get a little bit of a glimpse of it. But he didn't get any answers. Do you intend to answer questions regarding those various inquiries?
I thought he was raising questions for our consideration.
I
And that's
think
why I
you-
asked him, is he intending to pursue legal action based on the differences that he found in the ordinance and in the photographs of signs that he had presented to us? And he said no, he was just trying to give the town essentially food for thought to consider with respect to the passing of this ordinance,
Right, and,
which seemed fully appropriate.
but I don't know, were you not looking for a response, Mr. O'Hare?
Well, thank you for the opportunity to speak again. I just want to know what to do, how to act, and what land use I could put my property to and still be lawful. Because once the ordinance is passed, I don't want to break the law.
Sure. I think, let's see, get the ordinance passed, and then I think it's pretty much self-explanatory. I think it's clear. I think Mr. Ganger thought it was clear. I think it's clear. Quite frankly, I don't think a number of these things even fall under the purview of this ordinance.
Excuse me, if I might, what we're dealing here was a facial constitutionality question. And we're trying to address the facial constitutionality of it. If there's going to be an applied challenge at some time in the future, then we have to deal with that at the time. We're not talking about an as-applied challenge, we're talking about facial constitutionality. So some of these questions that are raised, we may not have the answers to today, and we may have to deal with that at a subsequent time. But I think you did address several of the comments that were raised. Mr. Ganger did in regard to the transient nature of the vehicles. We talked about a lemonade stand, and I answered that in a purely legal way, and said that you can't distinguish between the lemonade stand and something else. So those are things that, from a practical standpoint, that you're going to have to look at down the line. But we're dealing with the facial constitutionality of the ordinance at this point.
Well said. Okay.
Mr. Mayor, if I could add one more thing, I'm sorry to interrupt your time, but it's not just a burden on a homeowner to not be sure what's legal and it isn't legal, but people like Lieutenant Allen here, he's driving around. Oh yeah, I wanted to make sure it was him. He's driving around and he has to know what to enforce. Now, if he decides, yeah, this sign, it's okay. This sign, no, we're gonna throw the book at him. Well, that's selective enforcement. And it's not fair to him or any of the other officers to have to make those distinctions driving around town. Yeah, is a fake skeleton illegal? We're not gonna bother with that, that's ridiculous. But it is the law, so the law should be clear, so everyone understands it. That's all, thank you.
Thank you for the comments.
I will close with just one question, Mr. Mayor. You referred to Mr. Ganger and what he said, and he was dealing with trucks with signage. Am I correct that what you meant with trucks with signage are permitted in Gulfstream?
Commercial trucks identifying who the commerce is, it's a plumber, it's a baker, it's whatever, have always been. I mean, there's no change as far as I'm concerned versus our current ordinances and these.
So if it said Mr. Ganger is a creep, that's no good.
Is that the commercial, the creep company or what?
It would not be the creep company.
Well, what is it? What
It's just a name, someone making a political statement, which you're allowed to do in America.
For commercial purposes?
No, for political purposes.
But that's not part of this ordinance.
That has nothing to do with this ordinance.
You're just raising questions to talk.
Okay.
This ordinance has to do with signs on property. You're talking about trucks driving down the street.
Okay, so it does not include trucks driving down the street.
That's not how I read this.
Okay.
That-
And
We're
Mr.
talking about
Randolph?
signs on property, I believe.
The ordinance speaks for itself. I'll just let, you know, I don't think this is the time for a Q&A in regard to what might happen under this. I think these are all legitimate questions to be raised, but you heard me loud and clear, I think, Mr. O'Boyle, when I said that the town cannot look at the content of a sign to determine whether it's legal. And if it says Mr. Ganger is a creep and it's otherwise legal under this ordinance, then it's absolutely fine. Whether it says we love Mr. Ganger or whether we think he's a creep, that's not something that we can deal with. And I think the ordinance that's the intent of the ordinance, and I believe the ordinance speaks to that.
Right, so trucks with Mr. Ganger is a creep would or would not be permitted.
I'm not gonna get into a Q&A with you in regard to that. You might wanna address that in court when you get to court.
But I don't want to go to court. I wanted to get an answer as
Well,
Mr.
The content of it is not
You've got a
what's
lawsuit pending.
important. That's what he said.
Pardon?
It's not the content. It's the sign. Okay?
That's good enough. Thank you all.
Thank you. Any other comments? Yes, Mr. Martinez.
Again, you know, and just having had the opportunity to work with the police department and being a reserve in Ocean Ridge, myself there, I think, you know, the truck signs, obviously the benefit of having those on there is for Lieutenant Allen, Chief Ward, to be able to identify, you know, who's working in a development or in a house. And it makes it a little bit easier for them. It also helps them align their vision to see if they have a decal that says Town of Gulfstream on there, so it protects us as homeowners. So I think those are two different things. Personally, if somebody has a sign that says Bob Ganger is a creep, I can share this with you. I think that would be extremely, in my vision, whether it's legal or not, it would be extremely inappropriate. If there's anybody I know on that town commission, it's Bob Ganger, and I always kid with him when I grow up, I want to be like him. But I think, again, we're going back to intent and all of us trying to work together and making this a better town. And I think, you know, defacing or dehumanizing anybody, because we're all human, we all make mistakes, is not the appropriate steps. I think we should be able to work them out, you know, and move forward and make this a better town. Right now, I find this is the best town around, and if anybody can share with me what's a better town than this one, I will be more than glad to find out what they're doing and share it with you guys, because I really can't think of one. So, again, I'm just trying to add a little bit more dimension as a homeowner, and, you know, just trying to be as neutral as I can.
Thank you, Mr.
Sure.
Martinez. Anyone else? If not, we have ordinance 15/1 for our consideration. Is there a motion to approve on first reading?
Motion to approve on first reading, ordinance 15-1.
Second.
Read.
Commissioner Ganger?
Yes.
Commissioner Stanley?
Yes.
Commissioner White?
Yes.
Commissioner Orthwein?
Yes.
Mayor Morgan?
Yes. Next item was changed this morning. This is the attorney would like to discuss with us the lawsuit against the Sweet Apple Law Firm.
I think Rita had something before
Yeah,
that.
Mr. Mayor, we probably need a special meeting to go to second reading on this
Oh, I'm sorry.
particular ordinance. And, of course, we have to have advertising time. And I would like to suggest an appropriate time would be during the last week in January. The 29th is not available. So you would have Monday, Tuesday, Wednesday, or Friday.
Monday is what day?
26th.
26th. Tuesday the 27th. Anybody know off the top of their heads what the calendar is like?
What time?
It would be any time.
I
Except
would
after
wish,
4.
if at all possible, that it be the 26th. I've got to go to a NOAA presentations, 3 days, sorry. 27th, 28th, or 29th.
Okay.
That, and I really have.
Well, then if no one else has any other conflict, let's make it the 26th, which is Monday, correct?
Mr. Mayor, can you have like 10 seconds? 26th is the date, Mr. Mayor?
Yes,
Works for me.
that's good for you?
Yes.
A single purpose for the meeting.
Second reading of
Second
the
reading of the
ordinance
ordinance.
that you adopted
So what
on
you will
first reading.
advertise, that is the purpose of the meeting.
What time?
Early.
Early?
Yeah.
Usual 9
9
o'clock?
o'clock? All right, if there's no disagreement, 9 a.m. on Monday, January 26th, will be a special meeting for second reading. Good, thank you, Rita.
You're welcome.
Then, now we'll proceed to.
Yes, Mr. Sweetapple, who the town has appointed to represent it in regard to several of the pending cases against the town, his firm has been sued as a result of its being involved in the Citizens Awareness Foundation suits. And his insurance company is defending him in these lawsuits, but they're having to be out of pocket for their expenses up until their deductible, which is the $25,000 deductible. So Mr. Sweetapple has asked, because this suit results from his activities on behalf of the town, that the town commission reimburse him for his attorney's fees, or to handle his attorney's fees up to the amount of the deductible. I'm just bringing that before you as a request that was made by him, because that's something that you need to deal with and get consideration to. So that's the issue before you.
I may be the only commissioner, but I am unaware of what the substance of that lawsuit is. I really don't know what you're talking about.
It's a lawsuit brought against myself and Sweetapple based on defamation of character and various other calumnies. It is a suit brought, in my opinion, to try to undermine Mr. Sweetapple's representation of this town. And therefore, he would not be in that position of getting sued had he not taken on our representation and handled it in the fashion that he is handling it. He has a deductible under his insurance policy, and it would seem reasonable for me that we would help cover that expense, since he wouldn't be in that position if we had not asked him to represent us.
Is there an absolute limitation on what how much we would help him, because we're also compensating him for his services as an attorney.
Well, his insurance policy has assigned counsel to defend him, but there is a $25,000 deductible, as I understand it. So that's the obligation that he would be responsible for, and I think that's what he's asking us to cover up to. At least that's what I would interpret his letter to me.
And we have confirmation that his professional liability carrier is going or is currently defending him in the suit.
My confirmation comes through him, and he has given me the name of the law firm that is representing him. Yeah.
Is this normal? Because I think, we hired him as our attorney, and I know he's in the position of defending the town, but why would we be paying his deductible? I mean,
Well, we're basically paying the fees that he will be out of pocket as a result of being involved in the lawsuit.
Right.
It's not like you're paying his deductible, so to speak. You're compensating him for his out-of-pocket expenses that are involved in defending himself in the lawsuit that he became involved in because he's been representing the town.
If legal expenses can be recovered, would we get our money back for our participation in his defense?
Well, I would think so. I don't know the extent to which legal fees are recoverable because I'm not that personally familiar with the lawsuit, but you could certainly make that a condition or an addition in the event you do choose to reimburse him for those fees. You could indicate, obviously, that if they are recoverable, you would want your fees recoverable.
Is that the usual way when situations like this occur? Is that a common practice?
I've not had it happen before. I've not seen it happen before.
Well, one hates to see one's own attorney being blindsided in a situation where, in good faith, we've asked him to represent us, and I don't think we would have assumed, for the moment at least, that someone would then sue him for representing us. I mean, that seems outrageous. This whole thing is outrageous. I hate to say it, but it's just getting.
I agree with
You
that.
don't even have to hate to say it.
No, I don't hate to say it. It's just disgusting. But I would firmly agree that his goodwill and his reputation needs to be defended, and as does ours. So I would make a motion to approve, subject to the potential to recover, because at some point in time, we've got to start recovering these expenses. They're outrageous to begin with, and if you can't even recover some of them, it just seems to me as the system is broken. I mean, this is a kind of decision that you hate to make, but I think you got to make the right decision, and I would suggest that we agree, subject to the ability to recover, which may be beneficial to all, that we go up to $25,000 and not a dime higher.
I agree with that. I think that's well said. Is that a motion?
That was a motion, sorry, it wasn't well stated, but it's a motion.
Is there a second?
Is it possible to know more about this? I mean, I don't want to open a can of worms here, but, I'm with Commissioner White. Is this a common practice that we pay their deductible? I'm just.
We can bring you back more information if you want.
I don't want to be difficult about all this because he is defending us and I appreciate everything he's doing, but I just, before we,
You want to
our
defer to the
costs
special
are
meeting?
so huge. I just want to be careful how we're spending our money a little bit, to watch over it.
I don't imagine that time is of the essence in this issue, and if you wish to defer it to the special meeting,
Let's defer it.
Until January, is that?
To the special meeting on January 26th.
Can we do that? And then, you know, I think, maybe then we'd be more comfortable with what we're dealing with, you know, I just wanted to know if this is a common practice or what we're doing.
I think it's unusual. I don't think you're ever gonna find that this is a common practice, but we'll bring whatever information we can find back to you at that meeting, so you will feel better informed.
Okay.
But I don't wanna send a signal that this is any lack of faith
Oh, no,
in him
I am not sending
or the
any
process,
signal that it's a
and-
lack of
And that we
faith.
support him as much as he's supporting us.
Yeah, and I know this is a terribly unusual situation, as we all do.
I'm not sure, did we have a second? Or
We did not have a
No.
second, it was for
I
discussion.
would like to make some comments.
Okay.
In no way is this common practice. But I also feel that in no way can we hesitate or not commit. We are committed, and that we have contingencies sufficient for that loss. And from a staff perspective, I would recommend that you approve this at this meeting if possible.
Okay.
Your concern is
There's no question.
show,
We have to have a
Show
strong
support.
show support.
support as what we expected from him.
Well, I mean, you start with the proposition that it is unusual that Mr. Sweetapple would not be requesting it, unless in good faith he thought it was due, an appropriate action for the town to cover that expense. I trust him, he has supported us, he has been invaluable in putting together the defenses to protect this town. So I'm fully in favor of it, but if you would like more information, I don't think there's a rush. If you want to defer it, I think that's probably okay too. Tom, what do you think?
I agree, I haven't really seen this, it is unusual, but this is in a very, very unusual circumstance. I just think if we're gonna defer it to the 26th, then in a reasonably specific way, we should just outline before we move on exactly what we're looking for, you know, additional information, that would need to be provided to the other commissioners to make the decision. And I don't think a whole lot is gonna happen in a span of 14 days or what is it, 17 days until the special meeting, if everyone feels more comfortable with that. We should sort of give direction to the council, or general council, you know, exactly what we want to be provided between now and then.
Yeah, I mean, what questions would you want answered, or what information would you be looking for? I guess that's what Mr.
That's
Stanley's saying.
Exactly, pretty much why he's expecting to get this money back, which, I guess it was said by Mr. Thrasher and all that. I mean, he is representing us and he's gone out of them. And, you know, because it's an unusual situation, we're paying him and then have to pay his contingency. That's what I was questioning. More than, it's an unusual, very highly unusual situation. So I don't have a problem with it because of what we're dealing with. I just kind of wanted a couple of answers before we dole out another $25,000.
Well, I guess the question is, what would you hope to learn that we might, or not hope to learn? What would you learn that would lead you to vote against paying the $25,000? And that's not meant to be a leading question, because you
Yeah, no, I
may know
understand.
that something, I think minimally, we need to know the name of the firm that's doing this. We're giving money to somebody, and we don't even know who they are right now.
No, it would be his firm.
His,
It would be his firm.
so he will give it to him, and he will pay the insurance
Yeah,
company.
Yeah, he just wants to know that you have approved the ability for him to be reimbursed for the legal fees that he's expended on the case.
Well, I guess if there were a law or something that doesn't allow you to do this, in other words, are we doing something we shouldn't be doing? And I can't imagine what that would be. Compensate your attorney for his fees and expenses. This is an expense. an
Okay.
unexpected expense, but it's an expense. He didn't expect to be sued. We
Mhm.
didn't expect that he would be sued. He is being sued. And the question is that a legitimate expense?
He represents us.
Yes.
What he has stated, the public comments he has made are on behalf of our town.
Right.
He's the voice piece of the town. He has been sued for making those comments as defamatory comments and a number of other such allegations. He would not be in that position unless he were our spokesman. So, unfortunately, he has a high deductible under his policy. So it's up to 25,000. It's not 25,000. It's whatever the expenses are up to that point. I think we should cover it. I think it's appropriate to cover it, and I think it shows the continued support that we have for his efforts, and we should approve it at this meeting. But if you are uncomfortable and want more time, that's fine as well.
Well, if we approve it today, then can we just, I think we should at least get a letter from the law firm that's handling the suit on behalf of Mr. Sweetapple's law firm, that they are indeed handling the case on behalf of the carrier. And then also just confirming what the maximum deductible is for the record, if we do approve it today, that can be done after the fact.
Get a letter of their hourly rate as well.
Yeah. Yes.
Expenses that have been incurred to date.
Okay,
that's
and that
reasonable.
it's a result of his representing the town. This is, you know, the only reason why he's brought into this lawsuit. I'd be for it, that'd be fine.
Okay, should we go back to the motion?
Motion stands as amended.
Is there a second?
I second.
And it's my understanding, based upon Mr. Stanley's remarks, that you want to receive this additional information that he verbalized.
Yes. From council to you, as council for the town.
Mr. Mayor, may I comment before you make this official action?
Yes.
This is the first I've heard about this lawsuit. I don't know what it's about. It sounds like it's about Mr. Sweetapple doing something wrong. Attorneys represent towns all across the country, but they know when to keep their mouth shut. Because Mr. Sweetapple might have said the wrong thing, it's not the town's responsibility. Now, $25,000, that's sweet, but you have to also know that for months I've been trying to disqualify Mr. Sweetapple because he used to represent me. And it's not right, in my opinion, that he's now representing against me. He's already charged the town $20,000 for that. That's not the town's fault. He had an obligation to tell you that I was his client. He didn't. That's Mr. Sweetapple's fault. For him to charge you $20,000 for that and $25,000 for this, there is a law against that. It's called fiduciary responsibility with the public's money. Please think carefully before you continue to spend the public's money to defend Mr. Sweetapple, who's, I agree with you, is a very unusual attorney with unusual methods.
Well, you filed your motion in that case, and that will be judicially decided.
I'm sorry. I didn't hear you.
You filed your motion with respect to what you just spoke about, and that will be judicially decided. Thank you.
Right, you're
Any other
spending money for it.
questions from the public? If not, read it.
Commissioner Ganger.
Yes.
Commissioner Stanley.
Yes.
Commissioner White.
Yes.
Commissioner Orthwein.
Yes.
Mayor Morgan.
Yes. Thank you. Move on to items by the commissioners.
Mr. Mayor, if I could take a couple of minutes, just to post us all. A lot of what we're dealing with this past year has been as a result of the Public Records Act, which by any standard is considered a good law. In fact, it's by some standards considered to be the whole sunshine law of the state of Florida, is something the state is particularly proud of. And yet, we've seen what happens when the Public Records Act is abused. we're enduring that and have been for over a year. The Florida League of Cities, with which we in Gulfstream spend a great deal of time. Mr. Thrasher sits on several boards and committees of both Florida League of Cities and the Palm Beach County League of Cities, is very much aware that the Public Records Act is open to abuse, and in order hopefully to close some of the loopholes in the act, they've taken it upon themselves to act on our behalf to see whether or not the act can be amended in some ways to make it a little more difficult for people who are taking advantage of it to operate. Annually, the Florida League of Cities asks all of its members, which are 475 municipalities, to pick what they believe to be the top legislative priorities that the league should be supporting in the upcoming legislative, the state legislative when they meet in the spring of every year. As you know, our state legislature only meets for 2 months, literally to the day. And an awful lot happens in those 2 months. And in order to pick your shots, if you want to change any laws or bring new laws forward, it has to be a rather targeted effort. So the league is saying, tell us members, that is the 475 municipalities, including Gulfstream, what you would like to see done in Tallahassee in the upcoming session. And they begin the process with a meeting in Orlando, or actually in Hollywood, Florida, whereby committees are formed and representatives from a very broad array of municipalities, cities, meet over a several-day period and hash out what they believe to be the most important issues of the day. And I had planned on going because one of the issues of the day is sober house legislation. And wearing my other hat, I was going to go, and I asked Mr. Thrasher, was he going to go? And unfortunately, the day of this big meeting, he was in deposition. So I took his place and got myself assigned to the Urban Affairs Committee. And there were, at that point in time, several dozen, maybe I guess 50 or 60 proposed pieces of legislation. And nothing on the list for public records until I made a brief presentation, and people, there were like 50 mayors and commissioners, a few administrators in the room, and basically recounted what Gulfstream is enduring with respect to abuse of the Public Records Act. And it was rather eye-opening because what we found were a number, dozens of mayors saying, well, that same thing's happening in our city. And whereas I would have thought naively that we were probably the only one going through this process, it became very much aware that an awful lot of cities were coping with what they viewed as their word with scams. I cut to the chase, starting with that first meeting where people were unaware of what was happening here. They had three more meetings. Mr. Thrasher and I attended all of them. And to make a long story short, we made the cut list of some 500 proposed pieces of legislation, and they were only going to take 10. We were one of the 10 picked. When I say we, I mean the community who is concerned with abuses of the Public Records Act. And I'm pleased to announce that on my birthday, January 5th of this year, an act was filed. And the headline is Simpson and Bashir's filed legislation to stop public records scam. So, starting this week, committees and legislatures will begin to consider tweaking of the Public Records Act, which, by the way, is generally, I'll say it again, it's a good act. It serves a very useful purpose. No one wants to see it diminish in any way. What they want to do is to see that people are taking advantage of it, make it more difficult for them to operate. So there's a bit of caution here. The language of the initial filing is not to our satisfaction, and we need to work on it, and we are. There's a delicate balance here. You don't want to create a situation where people are frightened to file public records requests. Quite frankly, what you need to do is convince them that their requests are going to be handled better because of the changes in the Act. It's very clear that anyone who uses the law to harass or intimidate or extort is going to have a more difficult time operating at the state level. The state legislation is going to do something about it, hopefully. I caution you, however, that there are several thousand bills filed every year and only about 150 reach the governor's desk. So it is not a foregone conclusion that the act will be amended this year. We got a good plan. The league is absolutely committed to seeing this done. And the two, Mr. Simpson's, Senator Simpson and Representative Bashir's are both very good friends of small towns. And they look at this as from the point of view that small towns who don't have the resources to be able to handle an avalanche of public records requests, and the contractors who work with the small towns and who are drawing in on all of this are similarly affected. And both Senator Simpson and Representative Bashir's are small businessmen. And they know exactly what happens when somebody comes in and they can't produce a record fast enough because it was submitted to somebody who was just doesn't know what a public record even is. The analogy always used is the guy who's mowing the lawn in front of the city hall, and he gets a request and he doesn't know what to do with it. He puts it in his pocket, and 3 weeks later the city is sued, and then a settlement is made. And so this is something that it's a good lesson in civics. This is not an easy thing to accomplish, but I think that Gulfstream, our experience hopefully will not have to be endured by other municipalities in the future.
Thank you, Bob, and I want to commend on behalf of the commissions in the town, you and Mr. Thrasher for putting so much time and effort into working with the league to try to effectuate this legislative change. It's been a lot of work, and it proves that Gulfstream is not only actively defending the cases against it, but also trying to lead the way to make appropriate legislative change in the state to protect not just Gulfstream, but all other municipalities. Thank you.
Excuse me,
Any other
Mr. Mayor,
comments?
may I just quickly respond to,
I think this is a time for the commissioners to speak. We have a public comment period.
I don't think I'll be 30 seconds.
Why don't you just have a seat until we see if there's any other comments.
Thank you.
Any other items by the commissioners?
I just want to thank Commissioner Ganger for all his work on this. I think it's a very good, very, very good thing to do.
Certainly is. If not,
Thank you.
for full disclosure, please, Mr. O'Boyle.
Thank you, Mayor, for this opportunity. I heard what Mr. Ganger said, and I think for the most part, what he said is correct. However, I have, whatever I have in my hand, an article that came out this morning from the Florida Center for Investigative Reporting. And I just want to read you two quick sections. Number one, in this supposedly RICO suit, the town's star witness is a fellow named Joel Chandler, as you all know. And Mr. Chandler supposedly filed 200 records requests. And his statement here is the record requests that he filed were nonetheless lawful, meaning they were in accordance with the law. I also point out that Barbara Peterson, for those of you who don't know Barbara Peterson, Barbara is the head of the First Amendment Foundation in Tallahassee. Barbara Peterson was quoted as saying, Barbara Peterson, president of the Tallahassee-based First Amendment Foundation and the FCIR board member, thinks the proposed legislation limits access too severely. Proposed legislation limits access too severely. Yeah, in other words, that they're too severe. I don't know a lot about politics, but what I do know is